So we are going to talk about bankruptcy and reorganization. I trust that all of you have been through all of the corporate material, and you've been through much of the other material that we've talked about to deal with financial aspects of corporate management. Today, we're going to talk about what happens if it goes bad and a company has to dissolve itself and go out of business. Well, if you remember, we talked about corporations dissolving, going to their shareholders and saying, we can't do it anymore. Let's make sure that we pass out all the assets to our creditors and then to our stockholders and all of those kinds of things, so they can wind it up voluntarily, or a judge can make it mandatory that they wind up and dissolve the business. Well, bankruptcy and reorganization are ways in which a corporation can voluntarily go out of business with the assistance and protection of the Federal District Bankruptcy Court. And the question I put up on the very first slide is this a creditor's remedy? Normally, we think of what happens when somebody has too much debt and not enough asset to cover those debt, right? Well, what happens if a creditor carries a business, literally, supplying them with materials or with services for a very long time, and it doesn't look like the person who's running the business is ever going to pay the creditor back? What do? How do they get their money? Well, in a situation like that, the creditor can actually petition the bankruptcy court to dissolve the business and pass out the assets to the various creditors. So it can be a business owner's remedy if they're in trouble, but it can also be a remedy for a creditor who is attempting to get out of a contract or trouble where they are not being paid and they are starting to feel the heat from their creditors. Okay? So, okay, this happened last week. Chapter 7. What is a chapter 7? Well, as you can see, there's not just chapter 7 listed up on this slide. You have chapter 7, chapter 9, chapter 11, chapter 12, and chapter 13. They're all forms of bankruptcy relief. These chapters refer to the United States Code, wherein the various types of bankruptcy are set out and the provisions for how they work exist. Chapter 7 is the most complete and almost the most difficult for the owners of a business to go through. It is complete liquidation. They sell everything. You've heard of selling out to the walls. Have you ever heard of that? That's where a business says, we're closing, and they start having a series of sales where they sell everything at an increasingly deep discount until everything is gone. Well, this not only sells out everything to the walls, it sells the walls. It sells the floors. It sells the real estate that's underneath the store or the factory. It sells everything. It is complete and total liquidation. Everything is sold. That way, the individual has the protection of the bankruptcy court in distributing all of these assets which are being liquidated to all of the creditors. And once that's done, and that may take a period of several years. Once that's done, and it's all over, the debtor, who is the one who's liquidating the business, won't owe anybody anything, and they can start all over again. Chapter 9. Chapter 9 refers to counties, cities, towns, states, anyone in a municipality or in a city or state type of situation, a governmental situation that has problems perhaps with paying its debts to the police, to the firemen, to the bondholders that they're paying, or giving them money to use and invest for that county or that state. Just a governmental unit that needs to get rid of everything and have the protection of the court. Now, it was brought up last night that recently, in the last 5 to 7 years, Chicago had to do that. The mayor of Chicago went to the city council and requested authority to file for bankruptcy in Chicago. They voided all of their bonds, all of the taxes went out, it all went directly out to their creditors, so that everything was paid, but the people didn't get their money back who invested in Chicago bonds. The fire department didn't get the raises that they were due for that year. The police didn't get the raises they were due. All the budgets were busted. Just all kinds of things like that. But sometimes it absolutely has to happen. So that's chapter 9, adjustment of a municipality's debts. Then chapter 11, business reorganization. Chapter 11 and chapter 13 are almost, but not quite identical. Chapter 11 refers to a business who goes in and sits down with the bankruptcy trustee and says, here's our debts, here are all of our assets, here is all of our income. Can you help us put together a plan where we don't lose our business and we pay all our creditors? They are then happy, and the court will stop anybody from coming in and foreclosing on any of our assets or suing us for breach of contract. Okay? So how does this work? They actually go in with their accountants and their books, and they sit down and they show them all their assets, all their debts, all the income they have coming in. And then the trustee appoints someone who becomes the operator or holder in trust of that business. And that business goes and works underneath that direct trustee in order to function and continue business so that they can pay their ongoing debts. Now, there are ongoing debts. Not all debts are liquidated by a bankruptcy. And the owner then becomes what we call the owner at sufferance. So the owner at sufferance, you'll see that term pop up here later. That owner at sufferance is the one who is the bankrupt. They have a bunch of titles. The bankrupt, the owner at sufferance, they're the ones who own the business and are trying to work it out through this bankruptcy. Okay? But it is a reorganization plan. And oftentimes, when they get together, they have a meeting of their creditors, and there is a meeting of the creditors. They all get together and they talk about, will they accept this, will they not accept this? Sometimes the business has to offer them a premium on top of what they owe them for ordinary business. So if somebody owes me $100 and I'm one of the creditors of this bankruptcy estate, they may have to encourage me by giving me 103% or 105%. And we call that a 103 or 105% plan. That plan makes sure that it's okay with me. I'm getting my money back as a creditor, plus I have an incentive to let them do it. Okay? I'll talk about how that's similar to 13 here when we get to it. Chapter 12 is an adjustment by farmers. Most of you realize, having been through a lot of civil rights cases and through a lot of finance cases, that farmers have different types of finance that they have to deal with. They have to make loans for their crops, for the seeds every year. They have to sell their produce. They have to get the money back. They have to pay off the loans. But they have to put up with stuff that we don't have to put up with, like bad weather. They don't control that. And so sometimes they're going to go into debt with all of the money they need to invest in their farm for a year. But the bad news is that it snowed in July and all of their crops were killed. What happens? They can't pay back those loans. So there are special provisions for the creditors of farmers in chapter 12 that allows farmers to adjust and continue to operate their farm when they're going through a rough patch. Okay? Chapter 13 is like chapter 11. Chapter 11 is a business organization. Chapter 13 is individuals. Individuals like us. And you know, sometimes we can have trouble with a bank foreclosing on a house, or trouble with our credit cards, or having more debts than we can pay. And some of us may have to file for bankruptcy. Let me tell you something before I go any further. Bankruptcy is not a bad thing. Has anybody ever heard that it was? Yeah. Why? And who tells us that?
People who don't really know what they're talking about.
Just people who don't know what they're talking about. Okay. Tyrese, what do you think? Who tells us that filing for bankruptcy is a bad thing? El Paso just gave you the answer. One of the answers. Banks. Yeah, banks. Banks say that it's bad. Why? Because banks are the ones whose money it is that they lent to you, that they're trying to get back from you with interest, but you can't pay it, so you're going to file for bankruptcy, and now the bankruptcy trustee is going to tell them how much they can have. Right? Who else would think that bankruptcy is a bad thing?
Insurance companies?
Not so much insurance companies.
IRS?
The IRS? No, the IRS is okay as long as you pay your taxes.
Anybody owe money?
Pardon me?
Anybody owe money?
Any money to whom you owe money. Now, all of us carry in our wallets these little plastic cards, right?
Yeah.
Credit cards are unsecured debt. When you go into an individual bankruptcy, those become part of the bankruptcy estate. And we pay those off, right? And then at the end of the bankruptcy, when everything's all paid off, say we have a 103% plan that everybody has agreed to, 103% plan, what happens? We're released from that bankruptcy, and that credit card is gone, and that credit card can't keep getting interest payments from us on our monthly payments because we don't owe them anything anymore. So, let's say you go in to buy a house, and you need to have lines of credit established. Where do you find those lines of credit? How do you establish those lines of credit?
Paying off the debt.
Paying off debt from what?
Credit card.
Credit cards. Or from
Real estate.
real estate, from your house payment, or from
Car payment.
car payments. Well, you're giving them all to me. That's exactly right. Any kind of regular payment that you rotate through every month is the kind of a payment that goes on your credit score, right? Now, do utilities go on your credit score?
No.
Well, it is real estate.
They can. Yeah, they can. They can be reported to the credit bureau. So everything that you pay on goes onto that credit report. And that's okay. That's really okay. But in a bankruptcy reorganization, a 103% plan, there are some things that are accepted from that plan. And utility payments are one of them. And I'm going to show you and explain how the plan is set up as we go through the rest of this session. First, how do we get set up in a bankruptcy? We have the filing of the petition. We have the filing of the petition. We go in and we see our lawyer, and we sit down and we file a bankruptcy petition after we've shown the lawyer all of our debts, all of our income, everything that we own. They put that down on the form and they file it just like a regular court filing, because it really is a court filing, in the bankruptcy court of the United States by district. Okay? And it's a voluntary bankruptcy because we are filing it on our own. Now, the debtor, that's the person who's filing the bankruptcy petition, call him debtor here, doesn't have to be insolvent, but anyone liable to a creditor can file. So what does it mean if they don't have to be insolvent? It means they still have money, right? Could they make payments if they had to? Yes, but they may have missed a couple of payments. And a lot of, particularly in the case of car payments and mortgage payments, if you miss a couple of payments in a row, the car gets repossessed or somebody's going to file for foreclosure on your house. Okay? But you don't have to be insolvent. You can still have money in the bank. You can still have a good job, and they're able to then set that up so that the money goes into the trustee and you have protection. Because the one thing that happens as soon as that petition is filed, an automatic stay of any proceedings or any reclamations or anything, any forfeitures that are going to occur on your property is stopped. It's called an automatic stay. And they actually print an order out, send it to you, or give it to you through your lawyer. And you can tape a copy of it up to your front door. And it says, stay away. This property is protected. It is no longer subject to foreclosure if it's a house. If it's a car, you can put that order in the front windshield of the car. And it will say, this property is no longer subject to any foreclosure or reclamation. Okay?
Wait, how do you get that?
It's, when you file the petition, the court makes it out for you. It's an order that they give you. Automatic. It's automatic. They give one to everybody that files. Okay? So the voluntary bankruptcy, the debtor doesn't have to be insolvent. If it's an involuntary bankruptcy, let's say it's a business. If the business has gone into debt and they're not paying their creditors, but they're still doing business, the creditors can say, oh, no, look, man, I tell you what, you aren't paying us for the materials, but you expect us to give you materials that you can make and sell, and we're going to get in trouble with our own debts because you're not doing your job. So what we're going to do is we are going to file the petition with the bankruptcy court to force you into bankruptcy. And they can force them either into a Chapter 11 reorganization, or a Chapter 7 liquidation. A lot of times, the only ones that are filed against an individual with a business is the Chapter 7 liquidation. That's the one I see most frequently. So the automatic stay goes in place. All of the property of the estate is registered with the bankruptcy trustee and with the court. So what's the role of the trustee? The trustee is the administrator. The trustee takes money payments from you and distributes it to your creditors, if that's your business.
How would that work? How would that work if we had like a clothing line? So who would they be like distributing?
Okay, here's what happens. There are two ways that happens. One is if you have a job, we'll say, or if I have a job, or if anybody has a job, they send an order to the employer, which requires them to send them so much money out of each paycheck. That automatically goes to the bankruptcy trustee. And the bankruptcy trustee then distributes it to the creditors. If you are an entrepreneur and a sole proprietor, then the sole proprietor, that would be the person who owns the business, is required to send in either once every 2 weeks or once a month a check to the bankruptcy trustee, and the same thing happens. It's distributed to all of the creditors. Okay? But the property of the estate, which in the case of a business is the entire business, everything that's needed to do the business, which if you rent the building, we don't, the building is not owned by us. So what we do is all the stuff that's inside, like the tables and the chairs and the serving line, if we have a restaurant or something like that, everything we own inside the building becomes part of the property of the estate. Even the uniforms that the servers wear becomes property of the estate. And the bank accounts of the business become property of the estate. Once the property of the estate has been declared and recorded with the bankruptcy court and the trustee, there is a creditors meeting where claims are made. So we have to tell the bankruptcy court who all our creditors are. Makes sense, doesn't it? We have to tell them who they are so they can pay, so the trustee can pay them. And then the trustee holds a meeting in front of the court with all of the creditors, and they get up one at a time and they say, yes, we agree. Yes, we will go along with this plan. Particularly if it's a 103% plan where the creditors receive not just 100% of what the business owes them, but 3% on top of that as an incentive. Generally, they will go along with that. I rarely see somebody get up and say, no, I won't go along with that. If that happens, then the court tells them what they're going to get. It's easier to agree. So at the creditors meeting, they all get together and they file their final claims. Now, there are exceptions to what can be in a bankruptcy estate and what the trustee is allowed to pay for by law. One thing that I think many of you have that cannot be discharged in bankruptcy. You know what that is? No.
Is it like an object?
It's something like money. What do you use to pay for your education? Student loans. Student loans cannot be discharged in bankruptcy. They hang on forever until they're paid.
So what happens if, like, you die?
Okay. If you die, several things can happen. If you die with your student loans still in place, the court may say your parents have to pay it. For your estate, if you have an inheritance that's coming to you, will have to pay it. In nicer cases, when you have folks who have lent money that are really nice, they will forgive that because your parents didn't have much to say about that. It was your loan for your education. But you think about it, the educational institution shouldn't have to suffer for it because at that point, your loan is credited back. The credits fall back and they don't have the money anymore either. So somebody has to pay for that, and it often ends up being your parents or your guardian, whoever that is. Okay? So student loans are an exception. Other exceptions are utilities. Things like water, electric, natural gas, things you pay for on a normal basis to maintain your life. Your rent is sometimes included in the bankruptcy estate, sometimes not. Mortgages are. Home mortgages are included in the bankruptcy estate, and what the trustee does is take over the payment. And they make the payment to whoever holds the mortgage until the end of the estate and its discharge. Now, here's a little glitch in the system. If you have a Chapter 13, which is reorganization, at the end, the bankruptcy trustee always says, yes, go ahead, you now have to take back over your payments on the mortgage, because it was just reorganization. All the other debts are discharged. Credit cards, doctor's bills, whatever was in there. You have to take that over. If a person decides to file for a Chapter 7, once their debts are discharged, the bank has the right to foreclose on their house. It's not reorganization, it's liquidation. So remember that. 7 is not good for mortgages and houses. Because when the bankruptcy estate is discharged, the bank has the right to file for foreclosure. Chapter 11 reorganization, the bank does not file for foreclosure, but they expect you to make your payments on a regular, recurring basis, the way it's supposed to be, because all your other debts have been discharged. Okay, got that? Okay. The powers of the trustee. The trustee has some general powers and some specific powers. The general powers of the trustee are to administer the estate on behalf of the bankrupt, to ensure that their debts are paid to their creditors. That being said, they have specific powers to adjust the payments to and from your employer and to and from the debtors and creditors to ensure that all of the payments are made on an ongoing basis. For example, let us say that you have an automobile payment and you have credit card payments. Your automobile is paid off during the bankruptcy estate, but you're still required to pay the same amount of money into the trustee. The trustee isn't going to send you that extra money. The trustee is going to take that money and redistribute it to the credit card companies to pay them off that much quicker. If that happens, the estate can be discharged early in some cases. So, your car is paid off, the money goes to other creditors who are not yet fully paid off. But then the mortgage keeps going and going and going because you're in reorganization. And it's always the same. So that's a specific power. The power to adjust the amounts of money and the payments to the creditors to get the bankruptcy estate paid off as quickly as possible. There are some voidable rights that the trustee has. They generally are very specific to each individual and have to do with, say, minors and other aspects of the estate. And preferences. The trustee has some preferences. One of the preferences, and we talked about this when Tyree asked me the question about where does the money come from and how does it get into the trustee. Generally, payment for services rendered go in 10 to 15 days before the payments are due on that particular set of creditors' bills. So, ordinary payments of utility bills, which are not a preference, fall to the individual bankrupt person. The rest of the bills that were past due and were part of the bankruptcy estate are then sent off to their individual creditors. Liens on debtor's property. Any of you heard of a mechanic's lien? You heard of a mechanic's lien? Okay. When you're having house repairs done, if payments are not made to the plumber, we'll say, who did the work on the house, and he was a subcontractor from the general construction company that did all the repairs, but he wasn't paid, he can file what we call a mechanic's lien against the value of the property. It's filed with the county in which the property exists. What that means is that when the property is eventually sold to someone else, it's sold from me to another party unknown at this point, then that plumber's money comes out of the sale price of the house and is paid. But that lien is not part of my bankruptcy estate. That's part of the property value, and so is not a part of the debts that are paid by the trustee to my various creditors. And when you get to the point where you're buying property and you buy a house, one of the things you're going to make sure is clear is that there are no liens on that property. Because then, once you sign for the deed and the mortgage, then we become responsible for those when we purchase that property. And it just keeps going and going and going and going and going until eventually it's paid. And that's why we want it to be paid by the seller of the house as soon as the property is sold. We want to make sure that, so we always ask about that. And if we have a good lawyer and a good title company, they'll find it. You know, that's what title companies are for, right? Title companies are a specialized real estate company that goes in and does research to find things about mechanics liens, to find things about people who owned the house before that didn't discharge all of their responsibilities based on the value of that property. Those things are called what we call a cloud on the title. And so what they do is they go in and they report to the attorney, and the attorney goes back to the seller and says, we expect these to be cleared before we give you the final check. And they have to be paid off by the sale property before the transaction is completed. Okay? Fraudulent transfers. Fraudulent transfer. What is a fraudulent transfer? Well, you remember we talked about fraud, right? Fraud. What is Miles?
My question was on that, the mechanics lien.
Yeah,
So what are they doing, like, let's say that property doesn't get sold, like that person owns that property for like 20, 30 years, that mechanic won't get paid until that property is sold?
That's right.
30 years?
30
So
years,
it's just like bad debt or whatever.
30 years, yeah. And it just sits there because that property is eventually gonna be sold to somebody and that lien will be cleared.
The person could be dead.
Yeah, they could be. But when the property is sold by their estate, then the mechanics lien gets cleared. Now, fraudulent transfer, in the case of a bankruptcy estate, is when someone takes property and transfers it to someone else, knowing that they're going to go into bankruptcy, or going into bankruptcy approximately 18 months after the property is sold or given away. Last night, I did this same lecture, and I used the example of a 7-carat diamond set in a platinum setting for a pendant that's worth approximately $3.4 million when it was first sold, okay? And in order that that wouldn't go into the bankruptcy estate, the person who owns that property transfers it for some ridiculous value, $5, to one of their family members. Well, then about 15 months later, they file for bankruptcy. They'd pretty much known that they were going to file for bankruptcy all this time. So then they file for bankruptcy. And there are some whispers going on out there that a certain piece of jewelry is missing. And in fact, maybe one of the children goes in and says, "Where's mom's pendant?" And the trustee's looking at it. She says, "What pendant?" There's no pendant listed on the inventory of property. And the daughter says, "Well, there was a pendant, and I don't know if it was stolen or missing or what." And so the trustee starts digging. And they find out that this $3.4 million pendant should have been included in the estate. Well, that is called a fraudulent transfer because the debtor knew what they were doing when they did it. They did it just to defraud the estate and their creditors. So it's pulled back into the estate. It's revalued and it's sold for whatever the value is at that point in time. Let's say it goes to Sotheby's auction. Because, you know, Sotheby's, they deal in premium art and jewelry and paintings and just antiques and all sorts of things. And it sells for $7.5 million. Well, you know what happens to that $7.5 million? Poof, out to the creditors. Family never sees it again, never gets any value from it. Oh, and by the way, because it's fraud, and it's fraud on the federal court, the person who transferred it may end up with 5 to 7 years in the state. Because it's federal fraud. It's a federal crime.
I had a question. Did that one happen to the lady you were talking about? What's her name? Not Martha.
No, not Martha.
But,
That was, she was convicted of interfering with a federal investigation. Yeah, it's kind of, you know, they look into it, they try and get all kinds of stuff about it, and then they decide what's going on. It was a fraudulent transfer. Okay? All right. So the distribution of property, how does that happen? Well, you know, somebody who holds a mortgage on a house is somebody we call a secured creditor. Somebody who owns a mortgage on a business is a secured creditor because they have taken a property interest in that particular business for the loan that they're giving the business to start operation. Okay? So they are secured creditors, someone who's taken a security interest in the property or in the business itself. They'll be paid first. And they get all of their payment, including reasonable fees, like their attorney's fees for getting that, and interest. So they always get paid for it. They're like the bondholders in a corporation. When a corporation isn't doing well and it starts to go under, who gets paid back first? Bondholders, because they are considered to be secured. So, secured creditors have the first right to be paid. And then unsecured creditors. And unsecured creditors go by class. That's type of debt and when was it set up? How much was it? Who did it? That's what they mean by class. And then proportionally, everybody gets a proportion of the amount of money they're owed. They'll all get something until there is nothing left. If it's in Chapter 7, liquidation, they'll get something until everything is gone. The lowest classes, they don't get anything. Remember, like common stock, they don't get anything anymore? Well, that's it. Well, this goes up on YouTube.
Questions?
Yeah.
What measures for the class needs to be paid?
Well, it's defined in the federal statute, the classes and who gets to be paid in what order. And you can have as many orders of being paid as you have types of credit. And not only that, but you have it's all in a circuitous route. So every time creditors get paid a proportion, then the trustee will go back and pay the same class again with a proportion of lesser money that comes in, and it keeps going until everything's paid up. Okay? The discharge of the bankruptcy. The discharge can be revoked, but at the end, normally at the end of a bankruptcy, when everybody's been paid, the bankruptcy is discharged and all the debts go away. Normally. The discharge can be revoked if there was fraud, like that piece of jewelry, dishonesty by the debtor, they lied about their assets, or they lied during proceedings. They perjure themselves, because this is in front of a court. And the trustee is a federal officer, so they can't withhold information. So the discharge can be revoked. Now here's something we have to watch out for. Reaffirmation. A debtor may purposefully or accidentally reinstate their debt before the bankruptcy discharges it. How does that happen? Good question, you ask. Here's one way. There's a doctor, and this doctor calls and says, wouldn't you really like to make sure that I get paid because I saved your mother's life? I mean, I really think it's a duty that you have to pay me to make sure I get paid. His bill was in the bankruptcy estate. So what happens if you decide to send him something? The whole bill gets reinstated. And it doesn't get discharged, ever, until it's paid off. That's what reaffirmation is all about. Okay? What if you have a car And you have established that once the bankruptcy is discharged, you can continue to make payments on that car, even though it's discharged in the bankruptcy. And the car dealer calls you and says, well, gotta start making your payments again, just like on your house. No, it's discharged. Only mortgages, which is a secured line of credit, essentially, with a time and a right that goes into first place, can continue to get your payments reinstated. That car is free and clear. Okay? So watch out for reaffirmation. Oh, also watch out if there's a bankruptcy that you know about. Make sure that the people who had the bankruptcy know that they're going to start getting letters from all kinds of car dealerships saying, isn't it great to buy a new car? You can reestablish your lines of credit. Probably not a good idea right away. Probably not a good idea. Okay. I've seen that happen. More bankruptcy terms. Well, we talked about reorganization. And any debtor can, use the bankruptcy statutes against an individual except a stockbroker or commodities broker. Why would a stockbroker or a commodities broker not be able to make a debtor file bankruptcy? You all just got a question insured on bankruptcy filing. What? Because they're all leaving. What? Why would a stockholder, or probably no, why a stockbroker or commodities broker not be able to force someone into bankruptcy or a business into bankruptcy?
Does that have to do with their career?
No, but you're close. Very close. Stockbrokers and commodity brokers hold what? They hold your stocks and your bonds and your commodities, don't they? They already possess that property in their accounts, in their company accounts, and they get paid for doing it. So how can they force you into bankruptcy if they're holding your assets, which they can use to offset any debts to their firms? That's why they can't use these statutes. Now, sometimes people can use what we call a private workout. And a private workout is something that your attorneys will get together with a committee of those who are owed money, our creditors, and just say, how much will you accept? How much time will you give the individual to do this? I'll handle the money and I'll pass it out. And they don't go to bankruptcy court. Why would they not want to go to bankruptcy court? Why would someone not want to go to bankruptcy court? Well, it saves time because they want to get paid, and what happens in a court proceeding? People can come in and watch, can't they? So a private workout is a procedure which is done entirely in the dark. Nobody knows about it. Nobody has to know about it. It can be a private, contractual type of action in which the creditors and the debtor get together and nobody else knows about it. So they may prefer to do it that way. Now, there are disadvantages, and the very first big disadvantage is there's no automatic stay. So if those creditors decide they don't like what's happening in the private workout, they can still force the debtor into bankruptcy. Okay? But the reason a lot of people don't like it is because everybody knows their business. A debtor in possession is someone who is the former owner or the owner of the property. A person whose house is in bankruptcy estate. While they are the debtor and they are still paying on it, they are called the debtor in possession because they possess the house. Nobody's going to make them move out. Okay? Collective bargaining can be used. Collective bargaining is also a form of private workout. The creditors committee. These are all the creditors. We get them all together. We let it be known who they are. We invite them in for a meeting, or the trustee does. And the reorganization plan is the formal plan that the trustee comes up with, and everyone who's involved as a debtor signs it, and then all the creditors sign it, and it's filed with the bankruptcy court. We talked about the individual repayment plan where we filed the petition. We confirmed it. There can be objections to that plan. Creditors can individually object, but if they do, they have to say what they will accept in objection. The plan can be modified from time to time, like changing the amount of money that goes to the various creditors once each debt is paid off. And then discharge. Discharge is the final form of relief. Family farmer plans. It's similar to Chapter 13 for businesses, in which they reorganize and they do the same thing as individuals do under Chapter 11. And then, that's all we have. Does anybody have any questions about that before we're done?
Can you go back real quick?
Can I go back?
Just that one.
Oh, just this one?
Yeah.
Okay. That's the last slide. Go ahead and you can copy that down.
Mhm.